Okay, good morning or good evening, class, whenever you are choosing to watch this. If you do choose to watch this, I know that it is recorded and we are not having our typical face-to-face interaction. So hopefully you do watch this, get something out of it, because there will probably be some sort of question or two or three on the final from these recorded lectures, just to make sure that you have indeed watched. So for this lecture, because we got the curveball thrown at us by the mid-semester finals, whatever that was, for the 7.5-week classes, I don't know, Schreiner thing. All I know is that we have a 15-week class, so we could not have class on, let's see, what was it? It was Thursday, February 29th, we did not have class. So what that means is that this recorded lecture will have both the week 7 and the week 8 chapters. And really it will be two recorded lectures because this PowerPoint won't let me put these two slideshows together. So there will be two recordings for the week that we made up. It'll be chapter 7 and chapter 8. So we're going to go ahead and begin with chapter 7 here, which is homicide. And chapter 8 is assault and battery. I have no earthly idea why they put homicide in front of assault and battery, but we'll just start with homicide because it's more fun anyway. So let's go to what common law says first about homicide. As we normally do, we start with common law to try to get a grasp on what the background is of the law, how the courts have interpreted the law, and how legislatures have articulated the law back in the day so that we know where it's at today as we stand, especially in Texas. So at common law, we had our basic murder, and that required malice aforethought. Now, malice aforethought is just a fancy way of saying basically four different things. It's a term of art and it refers to homicide in any of these four ways that you see here on the PowerPoint: with the intent to cause death or serious bodily injury, with the knowledge that the action will cause death or serious bodily injury, when the killing occurred during the commission of a felony, which we will talk about later, or when the perpetrator intended to oppose by force an officer or justice of the peace in the performance of his or her duties. And then manslaughter was a little bit different. That was just committing a killing. Of course, you need to have a killing for homicide with recklessness or negligence. So we'll break those down a little bit here in just a minute. And let's start with a overview of what we're looking at here. There's a lot of topics involved with homicide. It looks like a lot to start with. It's not going to be that much. Of course, when we talk about homicide, we talk primarily about murder and what goes into murder. You'll see that malice goes into murder. That's the big one. And malice is essentially the same thing as premeditation and deliberation, which we'll find out. Then we have our voluntary manslaughters, which you intended to kill somebody, but essentially you had a good reason to. Felony murder is a murder that is committed during the commission of another felony. So if you're robbing a bank and somebody gets shot by one of your co-defendants or something during the robbing of the bank, then you've committed felony murder. You committed a murder that was a foreseeable consequence of the felony that you were trying to commit, the robbery in that instance. You have involuntary manslaughter, which we'll get to, and also the lowest of the homicides, negligent homicide. And Texas has that, so we'll talk about that in a minute as well. So starting with murder, let's get the big one out of the way. Murder, of course, requires a showing of malice. And premeditated murder, which is your big one, that's almost always going to be your first degree felony. That is an intentional killing that also requires proof of premeditated, willful, and deliberate conduct. That is, you are trying to kill someone and you succeeded, you committed first degree murder. So what is malice? You're going to see a lot of these courtroom verbiage, language, however you want to call it, that is a little bit funny, right? We have wickedness of disposition. hardness of heart, wanton conduct. Well, what the hell does all that mean? That cruelty, recklessness of consequences. Guys, it's just you are trying to commit murder. That's just break it down that way. It's you're doing something that is so far outside of the norm of societal standards that you have a wickedness of disposition, right? So I don't know where they got these terms. I don't know why they crafted them so intricately and so fancy, but just break it down to what it is. It's murder. You're trying to do it and you committed it. Okay. And that's going to be the distinguishing factor between murder and manslaughter in most jurisdictions. So, what is this malice? All this fancy stuff. Malice is just, it can be proved expressly and it can be implied from what they're doing, right? If you shoot a gun into a crowd, yeah, that's malice. Okay. So don't overthink it. It is something that can be proven at trial and often is by just showing that there was at least an extreme indifference to the value of human life. It can often be drawn out through simple common sense. That's all it takes usually to be able to tell if somebody has acted with malice. So we have malice, we have at least the extreme indifference to human life, and that takes us to premeditation and deliberation. So some jurisdictions require proof of sustained and meaningful deliberation to establish this element, and other jurisdictions require proof only of momentary reflection. So all that means is that no time is too short. If it takes me 1 second to decide I want to kill someone and I go ahead and do that, then that's enough for premeditation. That's enough for my mind to have considered it, decided that I wanted to do it, and commit an act that would go towards doing it, go towards murder. That's sufficient to justify a conviction for first-degree murder. Okay. And there's a lot of jurisdictions that have that rule. Texas does as well, that no time is too short for premeditation. I don't have to think about it for a day, for a week, for a month. As long as I think about it and I intend to do it, that's going to count. So why do we have that, right? Because if somebody decides in a split second to pull out a gun and shoot someone, we want them to be guilty of first-degree murder, of course. Because if we didn't have that rule, if we had to have a sustained period of premeditation and deliberation, like say that there was a jurisdiction that put a whole day on it, then those people that commit murder thinking about it just briefly, they would get off on something lower, like second-degree murder or even manslaughter. And that's not what the legislatures and the courts want, right? So the rule generally is that no time is too short for an accused murderer to have been able to premeditate. If you premeditate for 2 seconds, that's going to be enough in most jurisdictions. So then what is voluntary manslaughter? Guys, it's simply mitigated murder. Okay. You killed someone, you tried to do it. That's where the voluntary term is, of course. But it usually arises because you were reasonably provoked, or you acted in the heat of passion, or because you honestly believed that you needed to kill for protection purposes, but that belief was objectively unreasonable. And we're going to have a case that illustrates that better than I can for you right now, so we'll get there in a minute. But just remember that voluntary manslaughter, you tried to kill someone, but you had a legally justifiable reason that mitigates your punishment, that brings it down to voluntary manslaughter from actual murder, the crime of murder itself. So felony murder, we talked about briefly at the beginning. Most jurisdictions have this. Texas certainly has this. Okay. It transfers the necessary intent for murder from the accused person's commission of a specific triggering felony. So, like we talked about, someone gets killed in the commission of an armed robbery. Even if you didn't begin the robbery with the intent for anyone to be killed, if that happens, that's going to count as felony murder. Okay? Because, of course, like we've talked about in other classes, you're going to be liable for the foreseeable consequences of what transpires during a felony that you're trying to commit. It's not going to be an excuse to say, I didn't mean for that to happen. I only meant to commit this armed robbery. I didn't mean for anyone to die. The courts are going to say, well, yeah, idiot, what do you think happens during an armed robbery? And you're going to be liable for that. So we have all these terms and like felony murder and all this language up on the slide here, but guys, just use your common sense. It's what it boils down to every single time. Was the murder occurring during a separate felony? Did it happen? Yeah. Then yes, somebody's going to be liable for that. And the reason that the legislatures made this rule is to what? To hold people accountable and deter them from committing felonies in the first place. It's always going to be a good thing for society to be able to charge someone with murder that occurs during a separate bad felony that they're trying to commit. If you want to play stupid games, you're going to win stupid prizes, right? So that's the gist of what the felony murder statutes are for. So involuntary manslaughter. This is an unintentional killing without malice. And if we go back, we saw what malice was on the second or third slide. Go back and look at that. This is an unintentional killing without that happening. Now, most jurisdictions use a criminal negligence mens rea as an element for this. Some jurisdictions use the mens rea of recklessness. So Texas has both an involuntary manslaughter and criminally negligent homicide, which we're going to see in a second. So Texas has both, okay? And we'll break that down in a minute. But the point of involuntary manslaughter is that you did not try to kill someone. You didn't have that wickedness of disposition or hardness of heart, as the old courts called it. But you did kill someone, and it was through your negligence or your recklessness. So you're going to still be liable for that. Now, it's going to be less, right? You're not going to be punished with a first degree or even second degree felony. It's going to be lesser punishment because you weren't trying to kill someone, but you were acting so recklessly or negligently that your conduct did cause that death. So in Texas, your criminally negligent homicide is actually going to be a state jail felony. That's the lowest level of felony. So if you are criminally negligent in Texas and you kill someone, the most that you can be held in prison is 2 years. Lowest level of felony. Okay. Now, we also have involuntary manslaughter. That's going to be your third degree felony. That's if you acted recklessly, which, if you'll remember, recklessly is higher than criminally negligent. So reckless is a conscious disregard for obvious dangerous conditions. And so if you do that, that's going to be your involuntary manslaughter, and that's a third degree felony in Texas. But again, the point is that you committed an unintentional killing. You did not try to take someone's life. So going straight to criminally negligent homicide, like I said, in Texas, that's a state jail felony. You'll see that in section 19.05 of the Texas Penal Code, which we have at the bottom of the slide. And like we talked about, that's going to be lower than your recklessness. That is criminal negligence. That is the lowest level of mens rea. If you need to go back and refresh yourself, we of course have that PowerPoint for all the mens rea slides as well. But just know that that is the lowest level of homicide in Texas, and also the lowest level of homicide anywhere that you'll find. So going back up to the top of murder, right? Murder is divided into degrees in most jurisdictions. So homicides that are committed with the specific intention to kill are usually treated as first-degree murders. That is the most reprehensible form of murder, of course. You are trying to kill someone. You are doing it with malice. You want to kill them. You want to kill them for not a justifiable reason, and that is the mens rea of intentionally, right? You are purposely doing this, purposely, intentionally. It's the highest one. It is something that you've thought about that you are going to do and end up doing. So when we break down murder by degrees, the mens rea is going to be the defining factor because, of course, the actus reus is the killing itself. So the mens rea is going to be what differentiates things. So let's start with State v. Ramirez here. In this case, we have David knocking on the defendant's girlfriend's door, and the defendant opens it and gives David an aggressive handshake. They struggle for a bit, and then they stop. And then while they walked in the door, the defendant pressed a gun to David's ribs and said, "I could have took you out already." Nothing else happened. I don't know why David didn't leave, but I guess they kept going on inside. But nothing at all happens after that. And then a month later, defendant saw what he thought was David, but was David's brother. And the defendant approaches him and pulls out his gun and he shoots him 3 times and kills him, kills David's brother. Now, at trial, the defendant said that the victim started it, but he did nothing. All the witnesses said he did nothing. The defendant also claimed that the victim showed him a gun, but guess what? Law enforcement did not find any gun on David or anywhere near him. So at trial, the instruction was given wrong to the jury. And as we said, that's a common theme that we see in these appellate court cases, is that instructions were given wrong. So the trial court essentially gave an instruction to the jury that premeditation is just a period of time. But that's not what premeditation is. It's not a time frame that you can just put on it, okay? It's not just an instant of time. So it was not clear that premeditation requires actual reflection. So that's what we're looking at in this case. So the given instruction allowed the state to argue that premeditation is just a period of time or just an instant of time, and that's not correct. The instruction was not clear that premeditation requires actual reflection, and the instruction commented that the period of time can be as instantaneous as successive thoughts in mind, but provided no balancing language to the effect that an act cannot be both impulsive and premeditated. That's not logical. You can't do something impulsively, but also have it be premeditated. That's why the instruction was incorrect. So the defendant's convictions here are reversed because the instruction to the jury obliterated the distinction between first and second degree murder. Because if he killed him and he did it not premeditated, then you're looking at a lower level of murder, of course. But if he did it premeditated and the jury was instructed correctly on that, then that's first degree murder. And since they were not given the proper instruction, they could not come to a valid legal conclusion about if this murder was first degree murder due to premeditation. Okay? Because there needs to be that distinction. That's how we tell if something is first degree murder or something lower. Remember, that is the mens rea that we're looking at. All right. So what does the model penal code say about this? The model penal code does not divide the crime of murder into degrees, but it treats purposeful or knowing homicides as murder. Okay. Remember, we have purposely and knowingly. Those are our top 2 levels of mens rea. So in section 210.2, it says that criminal homicide constitutes murder when it is committed purposely or knowingly, like we just talked about, or it is committed recklessly under circumstances manifesting extreme indifference to the value of human life. Now, such recklessness and indifference are presumed, meaning it is shown essentially if the actor is engaged or is an accomplice in the commission of or an attempt to commit or flight after committing or attempting to commit robbery, rape, deviant sexual intercourse, arson, threat of force, arson, burglary, or kidnapping, or felonious escape. What is that, ladies and gentlemen? That was our felony murder that we talked about earlier. So that is right there in the model penal code. All of this above number 2, all of that is a felony of the first degree. Okay. So murder is murder under the model penal code. It is a first-degree felony. There is no second-degree murder under the model penal code, no third-degree murder. All murder is a felony of the first degree. So what does it say about manslaughter? The model penal code contains essentially what's commonly known as a heat of passion provision. So we have manslaughter, and it says that criminal homicide constitutes manslaughter when a homicide which would otherwise be murder is committed under the influence of extreme mental or emotional disturbance for which there is a reasonable explanation or excuse. Now, the reasonableness of such explanation or excuse is going to be determined from the viewpoint of a person in the actor's situation, under the circumstances as the actor believes them to be. All right. So, to determine if it's reasonable, you put yourself in the shoes of the person that did it, and you essentially ask the question, was that a reasonable act that they committed with the provocation that they were enduring at that time? That's how courts view it and try to answer that question. So let's look at a case to illustrate here. A defendant suspects that his girlfriend Carrie is having an affair. They argued for several days until his girlfriend decided to leave with their children. She said, I've had enough of this. I'm taking the kids and I'm getting out of here. She tells him that the relationship is over, that she's done, and she starts to pack her stuff. Defendant pleads with her to stay. She says, no, I'm not going to stay. He becomes enraged and he stabs her. As he's stabbing her, the children run into the couple's room and he chases them back to bed, and he goes back to their bedroom and continues to stab Carrie until she dies. The issue in this case was whether there was enough evidence to instruct the jury on voluntary manslaughter due to sudden heat, the heat of passion clause that we just looked at. The trial court said no. The appellate court said no. The trial judge did not have to instruct the jury on voluntary manslaughter due to sudden heat because the provocation must be sufficient to obscure the reason of an ordinary person. Mere words are not going to cut it. So how do we apply that to this case? The alleged provocation, her saying that she was leaving and packing her stuff, that was comprised of words ending a relationship followed by actions to leave. But her lawfully gathering her belongings does not go so far beyond mere words to constitute sudden heat. That's not enough because she wasn't provoking it. She was lawfully trying to leave. That's the point here, right? She wasn't doing something to him to provoke him. She was simply trying to leave, which of course she has every right to do. So the court said, no, that's not a good enough excuse. You can't kill people for that. Additionally, the court said, there's no sudden heat here because you had the time to reflect and cool off. The children came in and they stopped this thing. You chased them back to bed and then picked up where you left off on the stabbing. So no, that's not sudden heat. You were doing this for quite some time. Her leaving is not enough to provoke you for that. That's going to be murder. Okay, so there is a sudden heat clause, but if you look at this case, it doesn't apply here. That's not sudden heat. Sudden heat has to be something more. It has to be beyond mere words. So proving a lack of provocation. When provocation is offered as a defense, the burden of proof is beyond a reasonable doubt, or is upon the prosecution to prove beyond a reasonable doubt that the defendant was not provoked. This is very similar to self-defense in Texas, and I'm just using that as an example to try to show you guys. So when I try a murder case and I raise self-defense and I show that it's plausible that it was self-defense, then the state, the prosecution, they have to prove that it wasn't. So it's the same thing here in provocation. If I offer up a heat of passion defense and I show a minuscule amount of evidence showing that that's possible, that my client acted under sudden heat, then the state has to prove that he did not. Okay? So remember, the state always has to prove their elements, and that's going to be another element if I add that in. Sudden provocation or sudden heat. The state has to overcome that burden. So let's talk about imperfect defense for a second too, just so we don't get confused. Imperfect defense is when a defendant commits an intentional murder, but does so under circumstances in which he or she honestly believes fit within the parameters of a legal defense, but his or her belief is unreasonable. In real life, that's often seen with self-defense. Somebody thinks that they need to protect themselves and kill someone, but if you were to put yourself in their shoes, you would say, no, you might have believed that, but that was a completely unreasonable belief. Now, most jurisdictions recognize this. Where imperfect defense is recognized, the crime is usually mitigated from murder to voluntary manslaughter. So in real life, if you actually acted in self-defense and it was reasonable, you're not going to be charged with anything because you always have the right to defend yourself. But where you protect yourself and it wasn't reasonable, then that's going to be your voluntary manslaughter, okay? Unintentional killings. These consist, this is going to be your second-degree murder, your felony murder, your involuntary or reckless manslaughter. And the reason that we have all those options, essentially, is because there's a lot of variability among the states, okay? Most of the time, your unintentional killings are going to be your involuntary manslaughter. So let's look at this case here. We have defendant shot and killed his ex-wife in the kitchen of their home. It was his ex-wife, but I guess they were on friendly terms and they hung out all the time. The defendant was drinking all day, though, and he originally claimed that a bullet had discharged and struck his ex-wife in the head as he was cleaning his gun. However, during the investigation, he admitted to police that he himself had loaded the gun and that he knew how to operate a gun safely. He gave various versions of the incident until finally admitting that he had not been cleaning the gun, but had been fooling around when the gun went off. Drinking and playing with guns is not a good combination. So he told police that when the bullet discharged, the victim, or he was in the entryway of the kitchen with his elbows on his raised knees, and he had pointed the gun at his ex-wife and then accidentally shot her. So the issue for the appellate court here is whether that evidence is sufficient to prove the element of extreme indifference for second-degree murder. And again, guys, common sense. They said yes, of course. The jury was warranted in finding that his conduct occurred under circumstances manifesting extreme indifference toward human life. Obviously, that's extreme indifference. You don't drink 6 beers and then play with a gun in front of your ex-wife and put your finger on the trigger and load it and do all those things that culminate with the gun going off. That is extreme indifference to human life. That is, you just don't do it. And just use your common sense on that one. So they said that. They said you'd been drinking beer all afternoon and loaded and fooled around with a firearm when you knew that your ex-wife was in your proximity. That's reckless. That's extreme indifference. So yeah, your convictions are affirmed because the evidence supports the jury's verdict. They said that, yeah, that was extreme indifference to human life. That counts, okay? So let's go back to felony murder, because remember, that is an unintentional killing that happened during the commission of another felony. So in many jurisdictions, the triggering felony for felony murder cannot be an offense that is inherent in the act of killing itself, such as assault or battery or discharging a firearm. Okay, it can't be that closely intertwined to the other felony that you can be convicted of felony murder, because it's so obvious of a repercussion that it just intertwines like that, right? So we have independent felonies that have to be the triggering felony. That's going to be your robbery, your rape, arson, burglary, kidnapping. These are far enough apart from the killing that you're going to be liable for both. Okay? So if you commit arson, you intentionally burn a building down, and you kill someone inside that you did not know was there, you're going to be charged with felony murder. Okay? Same thing with all the other felonies that we see here. So again, remember that it is an unintentional killing, but you are going to be liable for it to a pretty hefty degree because you were committing another felony. Okay? So let's look at what we have here in Noakes v. Virginia. This is going to be coming back to involuntary manslaughter in this case. So the defendant runs a daycare from her home. She had been taking care of a 15-month-old baby who consistently stood up and cried in the crib while the other children slept. I guess he did this every day. He would never sleep. He would just stand there in his crib and cry while the other children tried to get their naps in. So finally, the babysitter, in an effort to get him to lay down and fall asleep, put a cardboard cover and a 33-pound dog crate on top of the crib so that he could not stand up, and so that he would try to quit standing up and theoretically lay down and go to sleep. Well, after she does this, she comes back 3 hours later and finds the baby unconscious with his head and neck wedged between the cover, the dog crate, and the crib. He had gotten stuck there while he was standing up, and unfortunately was pronounced deceased at the scene. So the issue here is whether an involuntary manslaughter conviction will be upheld if the defendant should have known that particular conduct was likely to cause substantial harm. And the court said yes. An involuntary manslaughter conviction will be upheld if a defendant should have known that particular conduct was likely to cause substantial harm. So here, the defendant knew or should have known that her deliberate actions were likely to cause harm to any child, much less to a 15-month-old baby with a propensity for standing in the crib. The court is saying here that the babysitter should have known that kid was going to stand up, and in fact did know, and could have gotten stuck, and in fact did get stuck. She should have known that. It was negligent. It was reckless, essentially. Here, they focus on criminal negligence, and they said, no, you should have known better than that. You are liable for this as an involuntary manslaughter, because that's what the evidence shows. So let's look at another example here on State v. Brooks. This is kind of a strange case. The defendant owned a home with a driveway heater, and exhaust fumes from the heater exited through a vent in the garage. So this is a series of pipes and other stuff that heats the driveway to melt snow so you can park your car. Now, in November 1987, two other home occupants, Jill McDermott and her child, became ill from the exhaust fumes from the driveway heater that had escaped into the house. Defendant called a plumber and an inspector to examine the system, figure out what was wrong, and they both concluded that a bad flap was preventing proper ventilation and that the gas should not be turned on until it was repaired. So the driveway heater should not be used until it's fixed because it was emitting basically carbon monoxide into the house. And of course, the defendant knew that because Jill McDermott told him. She said, hey, I got really sick one night. It must have been because of that. They checked it out. Sure enough, it was. However, the defendant put the house up for sale without replacing the heater or disclosing that issue to the real estate agent. So a family buys the home. And one night in December, first snow of the year, they turn the driveway heater on and put their children to bed. The next morning, it was discovered that all of them except one of the children had died from carbon monoxide poisoning. So the defendant was charged with involuntary manslaughter by reckless endangerment. Several witnesses testified that the defendant knew the heater was broken when he sold the home. And he knew, of course, that noxious fumes were coming in because of it when it was turned on. So the issue is whether the defendant's failure to disclose the faulty condition of a heating system he sold can be considered as recklessness, thus leading to a conviction of involuntary manslaughter. The court said yes, there is sufficient evidence here to support the finding that his failure to disclose the existence of the malfunctioning heater before selling his home amounted to a conscious disregard of a substantial and unjustifiable risk. Because what do we know here? We know that the defendant knew that the heater was malfunctioning and emitted noxious fumes. Despite that knowledge, knowing it was dangerous, despite that, he did not tell anyone. He did not tell the realtor. He did not tell the family that purchased his home. So his convictions are affirmed because the jury could have reasonably concluded, and in fact did reasonably conclude, that the defendant had the requisite recklessness necessary for involuntary manslaughter. So he's liable for that. And we want people to be liable for that because it's reckless to put others in danger when you could easily avoid the problem. All he had to do here was tell them that that condition existed. He didn't even have to fix it. As long as he told them that that's what was going on before he sold the house, he would have been in the clear. But he did not tell anybody when he knew that it was a danger. And that's why he is responsible and can be convicted of involuntary manslaughter. So the model penal code differentiates between manslaughter and negligent homicide. And remember, guys, what is the difference between these two? It's just the mens rea. Manslaughter is going to be your recklessness. Negligent homicide is going to be, your negligence. Okay. So, and you can see what the model penal code here says about these two things. Criminal homicide is manslaughter, like we saw before, when it's committed recklessly. It's a felony of the second degree. Manslaughter is under the model penal code. And then negligent homicide. I like this wording here because it's just funny. It's so obvious. Criminal homicide constitutes negligent homicide when it is committed negligently. Negligent homicide is going to be a felony of the third degree under the model penal code. So here is a good example of what's going to be negligent homicide, essentially. Here in this case, it is called involuntary manslaughter, but in this jurisdiction that he was in, they called it involuntary manslaughter, but the point of this is that the mens rea, you'll see under the ruling section here, is negligence. So what happened? A jogger was attacked and killed by two Rottweilers who were running loose in the streets. Now, the dogs belonged to our defendant, and the defendant admitted to police that the dogs had gotten loose twice that day, and that he picked up the dogs at a street intersection at about 9 p.m. on the night that the jogger was killed. The defendant was charged with involuntary manslaughter because his dogs were the ones that killed the jogger. At trial, two neighbors testified to having seen the dogs running loose that night and that the dogs were acting aggressively. Other witnesses testified that it was not uncommon to see the dogs loose in the neighborhood and that the dogs were very aggressive. Animal control officers also testified that they had picked up the dogs at least 3 times before the jogger was attacked. Lastly, a local ordinance outlawed leaving a dog unattended outdoors, unless the dog was restricted to the owner's property by a restraining device. So it was illegal, essentially, to have loose dogs. The issue is whether the evidence was sufficient to establish involuntary manslaughter. And the court said yes, an involuntary manslaughter conviction will be upheld if a death is proximately caused by culpable negligence. Now remember, guys, what is proximately caused? That is it foreseeable? Here, it's foreseeable that your two giant Rottweilers who got out all the time accidentally killed someone. So the court says the jogger's death was proximately caused by the culpable negligence of the defendant because the defendant repeatedly violated the ordinance that was designed to avoid this type of scenario. So his convictions are affirmed because the evidence supports that he intentionally, willfully, or wantonly ignored the ordinance or violated the ordinance outlawing unleashed animals, essentially. So they said, yeah, you're negligent for that. This death was caused by your negligence. It was reasonably foreseeable that your negligence in letting your Rottweilers run loose throughout the neighborhood could end up with an unfortunate death such as this. So you are going to be liable for this involuntary manslaughter with criminal negligence. So let's go to hypothetical 1 to try to wrap this up and get our minds around all of these different things. And remember, guys, it's always going to come back to common sense for this. Homicide is obviously the most well-known felony. It's the one everyone talks about. It's what's in the news all the time. So you would think it would be really complicated, but I promise you it's not. All you have to do is look at the mens rea. So let's go with hypothetical 1, the perils of criminal defense. This is very likely to happen to me one day. A defendant becomes upset with an attorney after the jury finds him guilty. And while the prosecutor was conducting sentencing arguments, the defendant just started beating up his attorney, savagely attacks him. And the audio recorder captured the defendant making statements showing his intent to kill. On top of him, beating him up, I'm going to kill you, I'm going to kill you. This is all your fault. I knew I should have killed you before this trial. Things of that nature. The defense attorney had to be hospitalized and put in intensive care. So our question is, was the defendant's act sufficiently premeditated to support conviction for attempted murder? So remember, it doesn't have to be premeditated for a certain amount of time. As long as it was thought about and done, then you have the necessary premeditation there. So what's going to happen in this one? Yes, that's going to be premeditated. That is going to be sufficient to support a conviction for attempted murder. The defense attorney wasn't doing anything to provoke the defendant. He was just sitting and listening to the prosecutor. The client or the defendant built up this idea in his head and then acted upon it. Okay, that's going to be your premeditation, and there's not going to be a defense to that. So let's skip ahead to hypothetical number 4. We're not going to do all of the hypotheticals for these chapters because that would just take forever. So I picked the best ones that I think illustrate the ideas that we're talking about the best. So what happens in number 4? Uniformed police arrive at a residence to execute a no-knock search warrant. The officers yell, "Police search," and then they break down the front door with a battering ram. As they get in through the doorway, a defendant fired a gun at the entering officers and killed one. Is defendant guilty of premeditated murder? Think about it. It doesn't take long for premeditation to form, right? The officers announced before they broke down the door, yes, he's going to be guilty of premeditated murder. The police did enough to announce their presence, allowing the defendant, even though it was short, time to premeditate and to actual reflection on what he was going to do. Okay, so he's going to be guilty of premeditation there. He's not going to have a valid legal defense for anything like voluntary manslaughter. Battered spouse defense, hypothetical number 8. So a defendant contracts with a third party to kill her abusive husband. She argues that she should get an instruction for imperfect defense because she believed she was in imminent danger from her husband, even though she felt no such fear on the day that she had her husband killed. Does that argument make sense? Yes, if she actually believed that. If she actually believed that, then she's going to get an instruction for imperfect defense. And remember, imperfect defense is when someone actually believes they were provoked, as she did here, but that belief is objectively unreasonable. So we're saying that, well, you had him killed, but you weren't in any fear or danger at the very time that you had him killed. So that's not going to be self-defense. It's not valid self-defense. It's an imperfect defense because she believed that she was in danger when you and I would put ourselves in her shoes and say, no, you weren't in danger right then. So that's why it would be an imperfect defense. And remember, what does imperfect defense do? It drops something from a murder to a manslaughter, almost always, okay? In most jurisdictions, that's what happens. So let's go to hypothetical number 12. This is going to be our high-speed chase. We've had several cases that are kind of like this, right? So a defendant is found guilty of second-degree murder due to the fact that he had run a red light while being chased by police, and after running the red light, he smashed head-on with another vehicle at approximately 95 miles per hour and killed the other driver. He argues that while he was reckless, the evidence supports only an involuntary manslaughter conviction and not a murder conviction. Is that correct? No. He had a depraved indifference to human life. That's going to be your malice, right? That's going to be murder. It was so reckless, so wild, so out there that it was a depraved indifference to human life. Your wickedness of disposition or hardness of heart, that's malice. That's going to fall under murder, okay? So let's go to our last hypothetical. A horse escapes from a fenced enclosure. The fence was weather worn, it was rotting, it was dilapidated, and the horse strayed onto a road after escaping and collided with a car, killing the passenger. So, assuming that the owners of the horse knew of the dilapidated condition of the fence and that horses had escaped from there previously, this is not the first time this happened. Could they be prosecuted successfully for involuntary manslaughter or negligent homicide? Guys, use your common sense. What is this? Negligence? Yeah, you bet. Yes and yes. History of escapes show awareness that these factors were known and that they were creating a high risk of harm, and that was in disregard to human life. They knew that their horses had previously escaped. They knew the fence was broken. They didn't fix it, and they knew or should have known that one of their horses could easily get onto the highway and cause an accident. So yes, that is going to be criminal negligence, if not recklessness, and that is going to sustain a conviction for negligent homicide or involuntary manslaughter. Okay. So on the next PowerPoint, which is going to be a different link, we are going to get into assault and battery. And despite it being a lesser charge than murder, it is a little bit more complicated. So we'll have to slow down on that one and try to get a grip on assault and battery. So thanks for hanging on with me, and we will get to the next one in a different link.